Good morning to all. Today we will going to discuss one case law from Trademarks Act 1999. The order is passed by the Delhi High Court, which restrained the Dabur company from selling its product. Okay, so let us see what that is. That is Cool King's Tanda. High Court restrains Dabur from selling its Cool King Tanda Tel, that is a hair oil, which is similar to the Imami's Navratna's Ayurvedic oil. So they have passed an interim order because they used the similar words, styles, and even colors of their label and packaging and get up and everything of their products. Let us see this, what the case relating to. This is order passed on 9th of August 2020. It is only an interim order. Imami Limited filed a suit against Dabur India, defendant for passing off an infringement of Imami's trademarks, design, and copyright with respect to its Navratna Ayurvedic oil. The court observed that Imami's Navratna oil has been in the market since 1981. They had first entered into the market, whereas Dabur Cool King Tanda oil entered the market only in May 2023. The similarities between the two products when compared, both in bottle and sachet forms, are stark and glaring. Observing the similarities between the two, the court said when one sees the two bottles, they are similar in shape. The slight difference in two shapes being so imperceptible as not to impress itself on an average customer. The oil contained in both the bottles is red in color, adding that use of red color for oil was also lifted from the red oil used by Imami. In present case, when one compares the bottles, that is products of the plaintiff and the defendant, it is prima facie apparent in consider my opinion, that is a bench opinion, that defendant has conscientiously imitated very nearly every essential and distinctive feature of the plaintiff product. Apparently, to capitalize on the goodwill and reputation earned by the plaintiff product over a period of time, it is not in dispute that defendant is only in the market since May 2023, as against the plaintiff, whose Navratna oil is being sold since January 1989. The Land Council has provided to the court physical samples of the two products. That is, photograph of the said products packed in bottles have been provided as document 11, filed with the plaintiffs, and photograph of the rival sachets and rival bottles have been provided in document 12, filed with the plaintiff. They may be produced. See below. See, both the oil bottles or colors are same. They written something in Hindi, that is also same. Similarly, that is Tanda, it is cool, everything. This is for your reference. Just come down. And another one also, they are also same. If you read this, cool, Tanda, and below that there are weightings also same. At the bottom there is something in Hindi, written in Hindi. That is also same with respect to Navratna oil and Dabur Cool King. Come down. Yes, when one compares the two products, whether in bottle or in sachet forms, the similarity are stark and glaring. Both packs have the same red background. Both packs use the words Tanda in the vernacular and cool in English along with the tail oil. Both packs have a motif of ice packs and red flower, apparently hibiscus. Both the packs have the words towards the lower edge. What it is written in Hindi? It is Rahat, Aram, Tarot Dajki. Am I right?
Yes, sir. Tarotazki.
Okay, I don't know Hindi, a little bit only know. In that order, whereas the limited pack contains the recitals over these weights. Asardar, Jadi Buddhi, okay, Saath, correct?
Yes, sir.
Okay. Both the packs have the weight Naya or new in triangular yellow background towards the upper left corner of the packs. When one sees the two bottles, they are similar in shape, slight difference in the two shapes being so imperceptible as not to impress itself on an average customer. The oil contained in both bottles is red in color. This is what they have said. It has been concluded that there was a clear attempt by Dabur to make it Cool King Tanda Tel product appear as similar to Imami's Navratna oil as possible. The court remarked that in its prima facie opinion, Dabur consciously tried to copy the essential features of Get-Up and trade dress of Imami Navratna Ayurvedic oil so as to capture the market, with the latter has assiduously developed since 1989. Therefore, Imami has succeeded in making out a prima facie case of passing off against the Dauber. At an ad interim stage, therefore, I am of the opinion that the plaintiff has succeeded in making out of a prima facie case of passing off by the defendant of its product as the product of the plaintiff and conceal's attempt by creating confusion in the market by adopting a trade dress which is deceptively similar to trade dress of the plaintiff. The court ruled this. The Dauber also placed a changed packing of the product before the court. However, the same has been rejected while observing that the changed packaging would also be infringing in nature. In present case, one compares the products of the plaintiff and defendant is a prima facie apparent in my considered opinion. The defendant has consciously imitated every essential and distinctive feature of plaintiff product apparently to capitalize the goodwill and reputation earned by the plaintiff product over a period of time. The court observed by ruling the clear prima facie case of passing off having made out against Dauber. Holding that Imami has clearly amassed considerable goodwill in respect of a Navaratna brand, the court passed the following interim order in its favor. Till the next date of hearing, the defendant is restrained from selling its product in any manner, in impugned packing or in any other pack which is confusingly or deceptive similar to the impugned packing. The replication of the essential features of the pack which have already been noted by me here in above in any other alternate pack which a different proposal would also tantamount to a violation of this order. So everything, the weights and everything they used are similar and is causing confusing bottle shape and oil colors. So everything makes the consumer to feel that this is an Imami's product instead of Dauber's product. At the cost of reputation of the plaintiff, the defendant is earning its revenue or selling its product. This is what the infringement and passing off done by the defendant against the plaintiff's product. Okay, any doubt?
No, sir.
No, sir.
No, sir.
Okay. Thank you.
Thank you, sir.
Thank you, sir.
Thank
I
you, sir.
will be taking the second section.
Yes, please.
Vishal, please allow me to share my screen.
Yes, Bhavna.
Bhavna.
Is my screen visible?
Yes, Bhavna.
So good morning, everyone. My name is Bhavna Parikh, as you all know, and today I will try to comprehend an ROC's order, sorry. This order is from ROC Kerala, Lakshadweep. It is with respect to two companies, one company and the managing director. The order is respect to the violation of Section 405 of the Companies Act, read with companies furnishing of information about payment to micro, small enterprise suppliers order 2019. The company is Blissful Garments Private Limited. Let's move on to the facts of the case. There was a complaint made by Tulip Elastics Private Limited that the said company is registered MSME in the business of manufacture of metallized yarn or gemmed yarn, etc. And the said company was obligated to file MSME form number 1, indicating the outstanding amount to the said complainant company, along with the number of days of delay, has not filed the same in the MCA 21 portal. So basically, the company has not filed MSME form number 1, which it was obligated to file. Since the company was a small company, hence there was some benefit under Section 446B, which was received, and accordingly, the following penalty was applied on the company. So before that, let's see what is Section 405. Yeah. If any company fails to comply with an order made under subsection 1 or subsection 3 or furnishes any information or statistics which is incorrect or incomplete in any material respect, the company and every officer of the company who is in default shall be liable to a penalty of 20,000 rupees, and in case of continuing failure, with a further penalty of 1,000 rupees for each day. After the first, during which such failure continues, subject to a maximum limit is 3 lakhs. Okay, I think this was the shortest summary I could have given on this order. This is it from my side. Thank you.
Thank you, Bhavna.
Thank you.
Thank you, Bhavna.
Thank you, Bhavna.
Thanks to all.
Thank you all.